Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us. Today we're going to be talking about bankruptcy, and specifically we're going to take questions from viewers, items that we received over the last several months. Joining me once again is my co-host Jesse Barrientes. Jesse, welcome to the show.
Thank you, Dave. How are you doing this evening?
I'm doing pretty well. Can't complain.
Well, very good.
Good to be here with you tonight.
Yeah, same here.
Now you have a slew of questions that were sent over the last several months that you've kind of compiled and put together, and we're going to kind of go through those.
Right, and you're going to be in the hot seat today, which is something that I enjoy tremendously, Dave.
It's always hot under these Klieg lights.
It sure is. Well, Amanda from Long Grove asks, how much will the bankruptcy cost me?
Price is something that everybody seems to be concerned about. Obviously, they're filing for bankruptcy. They don't have a lot of money. There's two main chapters of bankruptcy. There's a Chapter 7.
What does a Chapter 7 do?
A Chapter 7 is basically a fresh start. That's going to eliminate miscellaneous debt, such as medical bills, credit cards, personal loans, and you get to keep property that you want, such as a house and a vehicle, provided you continue to make payments on those items. There's also some other qualifications, but that's basically what Chapter 7 is, a fresh start, eliminating miscellaneous debt, keeping the property you want to keep, too much equity, and getting back on your feet, getting a new financial start. And you can do that once every 8 years under Chapter 7.
And again, asking about the cost, but again, I just had a quick little question to interject in there. So I can get rid of I can get rid of my student loans too. That's fantastic.
No, not a student loan.
There's certain debts you can't get rid of in Chapter 7?
There are definitely some exceptions. Student loans, recent taxes, parking tickets, child support, maintenance, moving violations, court fines. Those are debts that are going to stick around.
How about the iPath stuff? Because maybe I may have blown through a few of those, and I have acquired $50,000 in fines and penalties and interest.
Well, that would be incredible if you accumulated that much, but definitely non-dischargeable. So
Okay.
That's not going to go away because that is a fine to a municipality or a governmental body. So those debts don't go away.
All right, so that's a Chapter 7. Well, what's a Chapter 7 going to cost?
Chapter 7 is going to range in terms of price. At the time of this airing, the court costs alone are $306.
Yeah.
So no matter where you file a Chapter 7, anywhere in the country, even Hawaii, it's going to cost you $306 for filing fees. Attorney's fees are going to range based on the jurisdiction, the climate, how the attorneys are assembled there. But on average, I would say you're looking anywhere from $750 towards the bottom to $2,500 towards the top. So it's a wide range. There's a lot of variance in terms of experience levels of different attorneys, services they provide, experience levels, expertise. So there's a range out there, just like in anything else.
So, and of course, it would be, for example, if I had 3 or 4 major debts as opposed to having 37.
Well, there's definitely attorneys that charge based on what they see in front of them. If someone has 2 or 3 debts for less than $10,000, they're probably going to get a lesser fee than someone who comes in with 100 creditors,
Right.
up in the millions. So it's going to vary depending on what the attorney sees.
Okay. You were talking about a different chapter, too, other than Chapter 7?
Well, Chapter 13 is the other common chapter that consumers use, and that's a reorganization. That's where you're repaying either all or a percentage of your debt over time, and it's often used to save a home that's in foreclosure. It allows you to make your regular mortgage payment on time once again and pay the part that you fell behind, which is known as the arrearage, over the next 3 to 5 years. So it really gives you a long area of breathing room to catch up. And it's usually because the mortgage company won't let you catch up on your own. They want it all, lump sum, to catch up.
Right now.
They're getting a little bit more willing to work with you now because there's a crisis and they've got a lot of properties that they had to buy back through foreclosure. So they're a little bit more willing to let you work a payment plan, but typically Chapter 13 is the way that dictates, this is what I'm going to pay back, you have to accept it, it's going to work over the next 3 to 5 years, and if I can do so, I've eliminated the debt or repaid the debt over time.
And what's that going to cost me?
That's going to cost $281 for a filing fee. Once again, anywhere in the country, it's the same fee. This is federal law. Attorneys' fees are going to range, but on average, about 90% of the attorneys are charging the flat fee, which is approved by the court, which is $3,500. And that typically gets paid out over time. So you don't really need to come up with that much money for a 13 up front.
How much time?
Well, you can pay it off over 3 to 5 years. It gets lumped in. the attorney's fees, you become a creditor. So you get paid a little bit per month, the auto gets paid a little bit, the mortgage, and then lastly are the unsecured debts such as credit cards, medical bills, personal loans, and services.
So it just depends upon the term or the length of my plan payments.
Right, and the amount you're going to pay is going to depend on what you have in terms of income, expenses, and of course, the debt.
Okay. Lawrence in Joliet asks, will it ruin my wife's credit score if I file bankruptcy?
Well, it's going to depend on whether or not the debt is joint. If the debt is only in the gentleman's name, then he filing bankruptcy is not going to cause any problem for his wife. If, however, they have joint debt and he elects to file on his own, well, then the creditors can pursue his spouse.
But that's not going to affect her credit score. If he does file for bankruptcy and she's on the loan, I mean, I guess paying it might be another question, but that's not going to, just simply because her spouse files isn't going to plunge her score down to the depths, is it?
No, but it will affect her credit score because the Bureau is going to indicate that that particular debt was included in someone else's bankruptcy. She never filed, so she can definitely show her Social Security number if she goes for a loan. They can look it up and see that she never filed. However, the fact that he filed and they have some joint debt will bring her score down a little bit. Just the way it is.
Not as much as if she had filed, obviously, herself.
Right, but don't worry so much about the credit score, Jesse. Worry about getting out of debt and getting back on your feet. There'll be opportunities very quickly to rebound in terms of credit. 6 months to a year and a half to buy a vehicle, 2 years to purchase a house and get a decent mortgage, and about 6 months to a year on just about any other type of credit. So there is life after bankruptcy. Don't worry about the score. Worry about getting out of debt.
Sharon from Lake County asks, will I be forced to use my trust fund money to pay off my debts?
It's going to depend on what kind of trust fund it is. If it's a spendthrift trust, then it's protected. This is a very technical area. The bottom line is she would have to come in for a consultation. We would have to look at the trust documents, and we would have to make a decision on whether or not it's worth it to file. If it's protected, then a trustee can't touch it. So she can eliminate all of her debt and protect that money in the trust fund. If, however, we determine that it's not the type of trust that can be protected, then we're going to discourage her from doing a Chapter 7 because the court-appointed trustee would take the corpus or the principal or all of it and use it to pay creditors. So we want to make sure that that trust is going to be protected. If it's not protected, we might want to recommend a Chapter 13 and pay back the equivalent of what's in that trust over a 3 to 5 year period. So very technical.
So your advice would be for her to get in to you or to somebody who's competent about bankruptcy to be able to share and to let them know specifically what type of trust it is and everything like that.
Right. We would have to see it, and if it was something that we couldn't determine on its face, we would then get the advice of someone who handles trusts. Because the last thing you want to do is put one of your clients in jeopardy and see them lose an asset. You want to make sure as a bankruptcy attorney that you are not putting your client's assets at risk.
Okay.
And if so, you want the client to knowingly acknowledge that there's an asset that may be at risk, but I'm willing to give it up in exchange for a fresh start. A lot of clients are willing to do that.
Okay. Rachel from Inverness wants to know if you can rent during the course of your Chapter 13.
Rent an apartment, rent a vehicle, rent a storage locker?
Well, I would guess an apartment or a house.
Okay, you can certainly rent an apartment at any stage for either chapter of bankruptcy if you would otherwise qualify. So landlords want to see, can you put down a month's security deposit at least? Do you have income? How is your credit? Are you in the history of beating landlords every year? Or are you a good risk? So you do have the right and the ability to rent an apartment unless you're locked up, and then you don't have the right, but then you're living for free anyway. But yeah, you have the ability to rent, and you don't need court approval for that either. You can go ahead and get an apartment.
Well, I actually have a question based upon Rachel's question there in terms of Chapter 13.
Did you send in a written request?
I didn't, but
go ahead, Jess.
I think it relates.
Shoot.
She's in Inverness, so I don't know, what. Apparently, people everywhere.
Yes.
Anyway, so if you're in a Chapter 13 and you have your home, can you sell your home?
You can sell your home, but for that you need court approval. You have to bring a motion before the court. You need to show the contract. You need to be able to show the court what you're going to receive in terms of proceeds. And then the court is going to order that the proceeds first go to pay off your debt, and then any surplus would go to you. So that's why you need the court approval, because otherwise people would sell the house and they wouldn't pay their creditors. They would take the money and run, like Steve Miller used to say. Get the reference?
Get the reference.
Okay. Just want to test you there.
Hey, you're showing.
You're not a kid now.
A little bit, yeah. Little older there, Dave. Let's just relate it back. We talked about. Amanda asked about how much a bankruptcy costs. So, are these the typical things that would be included in the fee for Chapter 13?
Yes, Chapter 13 is a flat fee under the model retention agreement. That $3,500 that I quoted to you before, that covers all of your attorney's fees in a typical Chapter 13 case, other than an adversarial complaint, which is where someone is suing you in the bankruptcy court alleging some sort of fraud, or they don't want your debt to be discharged. So it definitely is a flat fee, and it could happen anywhere, month 2, month 10, all the way into month 60. And you have your attorney, you have your representation, you don't have to shell out or dig out and pay any more money. So it's a good deal.
Good. Jerry from Homewood wants to know, what does it take to prove that I'm in hardship, in quotes, hardship, to eliminate my student loans?
Okay, student loans. This comes up a lot, and Jerry from Homewood, it is very difficult, extremely difficult to eliminate a student loan debt. You have to basically prove to the court that you do not have the ability to repay it, you will never have the ability to repay it, and you have to go through a full trial and hearing on that matter.
Never have the ability?
Well, that's the argument that the government is going to use on a government student loan. For example, if you come in and say you have a certain illness, medical condition.
I have an illness that prevents me from paying you back.
Okay, well, the court is going to hear arguments that you might get a cure. You might come back. Your circumstances might change. So it's very difficult. It's not impossible, but it's very difficult, and I know very few attorneys who are willing to take those cases, because typically, if you don't have the ability to repay it, they're not going to be able to get any money out of you anyway. If you're not working, if you're on Social Security, if you're disabled, then having the student loan hang over your head is really not going to be a burden, because they're not going to be able to touch any of your assets anyway. So it's a tricky endeavor, and it's not one I recommend. And in my 21 years of practice, I haven't seen a client yet who qualified for a hardship discharge for student loans. That's saying something.
Yeah, it sure is. Nisha from Palos Hills wants to know. She says, I have an ex-boyfriend who signed on my auto loan. How do I keep him from being responsible for my repossession?
You can't, unless you want to pay the debt. Here's the deal. The boyfriend signed on the loan. So right when the vehicle was repoed, or when the payment stopped, that creditor had the right to look to the boyfriend for payment. Once they repo it, they sell it at auction. There's what's known as a deficiency. That's the amount that's left. Okay? It's sold for less than what was owed. There's a deficiency that can be collected upon. The person who files for bankruptcy is off the hook. So what is the creditor going to do? Look to the only party left who's liable on the debt, and that's this ex-boyfriend here. He's in trouble. I bet he doesn't sign for another girlfriend again.
So whatever you learned, right? So, but it's not just the deficiency. It's the court costs, it's the attorney's fees, it's the interest, it's whatever it costs them to repossess the car. Are all those things included in that as well?
Absolutely. So if she wants to prevent him from being harmed, she needs to continue to pay for it. Even though she's eliminated in a bankruptcy, she might be willing to protect him and possibly work a payment arrangement. She also might not care about him at all and could care less. We see that quite often, unfortunately.
All right. James from Chicago asks, am I responsible for my spouse's credit card debt? Ooh, that's a trick question.
Yeah, I would say basically if there's credit card debt that's used for a marital purpose, then the credit card company has the right to seek the non-filing spouse. However, if the debt was specifically or exclusively non-marital, then the credit card company would have a hard time bringing that kind of action. And we don't see a lot of this. Usually if the debt is only in one spouse's name and that spouse files for bankruptcy, there isn't any kind of attempt by the credit card company to hold the other spouse responsible. Although it is in the statute, they do have the right to bring it if it's for a family purpose.
But you haven't seen much of that.
I haven't seen it, no. They're usually too busy collecting on legitimate debts where they have somebody who signed on the dotted line and who hasn't filed for bankruptcy yet.
So if it's exclusively in her name, generally, it's her debt, and I shouldn't have to worry about that.
That's correct. But again, there are exceptions. Let's say some of that debt was for a child's medical.
But they're going to have to be able to demonstrate that.
Right, and that's a difficult proposition sometimes.
And that's what I was going to ask you. That's why I was saying, kind of a trick question there. In terms of medical bills, that doesn't gel the same way, does it?
No, medical bills are a little tricky there.
Even if I didn't sign for it, you hurt yourself and you went in and you incurred the debt. I was out of town working.
Yeah, well, this is that whole family purpose where I brought up the child or the spouse.
Family Medical Support Act, too, right?
That's right. That's right. If there is joint debt, though, I usually recommend that both spouses file together under the same fee, under the same case, eliminate it, wipe it out, start fresh together. That's my advice in those cases.
All right. Andrew from Naperville wants to know, how long does it take until the bankruptcy is final?
Well, if it's a Chapter 7 bankruptcy case, from filing until discharge, which is the end, you're looking at approximately 110 days. It takes anywhere from 4 to 6 weeks to get before a trustee after your case is filed. That's the time frame when notice will go out to all your creditors. You'll appear in front of a trustee. You'll answer a series of yes/no questions under oath, and hopefully the trustee will make a finding of no assets. You then wait out a discharge objection waiting period for about 60 days. That's when creditors have an opportunity to file an adversarial complaint and allege to the court that your particular debt or their particular debt should not be eliminated based on fraud or for any other reason that they can think of under the code. But usually, creditors will not object, and the debtor will get a discharge, a final paper saying the case is over, about 110 days or so after it's initially filed.
But I want a bankruptcy now.
Well, you get relief right now.
Okay.
Okay. The minute you hire an attorney, you get some relief. You can notify creditors, and those creditors must contact your attorney once you tell them that you have representation. In terms of filing the case, that stops wage garnishments, stops sale dates, bank seizures, repossession. So you do get some relief now, as you said it. You sound like the girl in Willy Wonka who wanted that thing now.
That's right.
You're not a bad egg, though. But anyway, you get relief right away. You just don't get the finality of it for about 110 days. So it goes by fast, Jesse. Less than 4 months.
Yeah, good enough. Joseph from Meadowup wants to know, can I file a Chapter 7 if I own a home and I am current on my mortgage payments?
Yes, you can file a Chapter 7 and be a homeowner. That's not a problem. The issue is whether or not you have significant equity in your home to the point where you would lose some of that equity to a trustee. Here's the example. In the state of Illinois, you're entitled to $15,000 worth of equity in your home that you can protect free and clear. If it's a joint case, husband and wife, you can combine that $15,000 and make it $30,000.
What if my in-laws are on the house too?
Well, your in-laws have an interest in the house beyond the exemption amount, so trustee would have to pay them their fair share, whether it's 50% or 25%, whatever they have.
But they wouldn't, say in a case like that, they wouldn't get they're not filing, so they wouldn't get $15,000 exemption?
No, they get the full share. So if they're a 50% owner, the trustee has to give them 50% of the equity right off the bat and just work with the remaining 50%.
And then that
the
30,
debtor.
And then the $30,000, $15,000 apiece would come in to play.
Right, and there's also the cost of sale. You do real estate, so you know if you have a house worth $300,000 to sell that, you're going to have an expense. 5% for realtor commissions. You're going to have title expenses, insurance, transfer taxes. So a trustee is going to want to see that there's significant equity to even think about taking a piece of property, putting it on the market, because there's got to be something left for creditors. Otherwise, it's just a burden to the debtor, and the debtor can fight that. So the equity is a consideration there, and I want to make sure that they have the right equity listed, not just what they think the house is worth, but what it's really worth. So we either want a realtor's opinion or a an evaluator, an appraisal. We don't want them to pay for an appraisal, but we want to find out with some certainty what that property can go for in the open market.
Yeah, that's a good question, because I think a lot of people think that if they own any kind of property, they're kind of stopped from filing a bankruptcy, and that's not true, because even if you can't do it under 7, you might be able to do it under the 13.
Right. There's a complete misnomer out there that people think because they own a home, they can't do a Chapter 7. They have to do the Chapter 13, which is the home saver case for the most part. Not true. And especially more and more today, as equity in homes is dropping or has dropped, there's more and more people that are either underwater or have very little equity, and they're entitled to a Chapter 7.
Okay. Sherry from Oak Park wants to know, says, I don't have the money to pay for the bankruptcy. What do I do?
Well, she can try and file the case herself, which I would never recommend. It's kind of like cutting your own hair or doing your own
I cut my own
tailoring.
hair.
You do?
No.
Okay, didn't think so. You can also try for legal aid. There are
Legal aid does bankruptcies?
At a very small level. But the best thing to do is get on a payment plan, work some kind of deal where you're not spending a lot, but you're getting the representation, and then once you pay the fees off, whether it takes a month or several months, the attorney will pull the trigger on the filing at that point. And again, remember I told you, once you hire an attorney, you get some immediate protection from your creditors in terms of your attorney will handle your creditor call. So the minute you hire an attorney, you should be afforded some sort of relief, which is worth it. And then just make your payments. Do what you can do.
So attorneys out there will let people make payments toward their Chapter 7 bankruptcy?
Oh, absolutely. This is bankruptcy. People don't have money to throw down a ton of money in a case.
Why won't they file it and then allow me to make payments while it's going on for that 110 days?
Well, it's a little bit risky because if the attorney files your case and doesn't have an agreement in place as to what's going to happen after filing, then the debt is technically eliminated. And then the attorney cannot even pursue or bill you for the debt. So the attorney fee becomes much like another debt, a credit card bill, a medical bill, a personal loan. It's eliminated in the bankruptcy. Therefore, the client would be able to make voluntary payments. But if the client chose not to make voluntary payments, the debt's discharged, and the attorney is basically working for free.
So you're out of
And
luck.
that wouldn't be fair either, right?
Right. No, sure wouldn't. Alicia from Park City wants to know, how long can I stay in my home without paying the mortgage?
Well, it really depends on the mortgage company. In Illinois, there's the Illinois Mortgage Foreclosure Law, which dictates what mortgage companies have to do to get the property back into their name and be able to evict. In Illinois, it's running at least, or I shouldn't say at least, approximately 1 year if somebody does nothing. If somebody defends the foreclosure and makes the mortgage company prove their case, you can probably get some additional months in that regard. But it all starts from the service of the summons. So until the mortgage company decides to take action, it's kind of like the big unknown. You're okay until they start.
And from the time
they start, from the time you're served with the summons,
right,
there's a couple different redemption periods. They have to wait at least 7 months before they can get a judgment. You have another 3 months after the judgment before it can be set for a sheriff's sale. They have to go back into court to get the sheriff's sale approved. And all along the way, you can be defending this action and getting additional time. So it's really a hard thing to say. I have some cases right now that are in foreclosure where the mortgage company has dropped the ball. These cases have fallen through the cracks. Clients call me up and say, what's going on with my case? Nothing.
They haven't done anything, even though
they've
started it.
They've started it. They might even be close to being finished, but they're not pulling the trigger on the finality. And it could be because we're going into the winter months. They don't want to have a vacant home. They want someone to preserve it and safekeep it. And what better than to have the homeowner in there? You know they're going to protect it, as opposed to evicting and then worrying about securing the property. So there's all kinds of different theories on why the mortgage companies are either dragging their feet or in some cases dropping the ball completely.
But sometimes with these foreclosure defenses, there's legitimate defense. For example, the mortgage company didn't do what they were supposed to do, or they didn't sign where they were supposed to do, or they did robo-signing, or any things like that, which would undercut that would be their defense to the foreclosure.
Yeah, there are certain defenses, but more likely than not, the mortgage companies, especially today, are getting better and better with proving the documentation, having all their ducks in a row, and making sure that they have the right to foreclose. And following the procedures is very important too. You want to make sure that that you're served with documentation. We've had clients that are living in the property, and the mortgage company has decided to publish the notice in the newspaper as opposed to serving them in the home. So there's little things like that that you can bring up as a defense that will gain you additional time and actually make the mortgage company do their job.
Well said. Morgan from Rolling Meadows wants to know, if I filed a Chapter 7 3 years ago, can I file again today?
No, you're not entitled to a discharge under Chapter 7.
Well, you can file one.
You can file it. It's going to get dismissed.
Right.
You can get Chapter 7 relief once every 8 years. Now, if you're someone who's filed a Chapter 7 recently and you need help, then Chapter 13 is available.
Well, what happens if you file a Chapter 13 within 4 years of the time that you filed your Chapter 7? Anything?
Well, you might not be entitled to a discharge. But again, that's a technical area where the attorney wants to look up exactly when your prior case was filed and to see whether or not you're going to be able to receive a discharge. In some cases, you might want to do a Chapter 13 and pay 10% back, knowing you're not going to get a discharge, because you're still holding those creditors off and you're still getting an affordable payment plan during the 3 to 5 years of your Chapter 13.
Ryan from Bolingbrook wants to know, how much money do I need to have to file? That's a
how much money?
Yes, yeah. How much money? You know, you talked about.
Or I think he means how much money is required in terms of debt. Is there a limit? Because some people call up and they've got $1,000 worth of debt. Obviously, it's not worth it to file.
Or $5,000.
Yeah, you know, it depends on the particular case. For some people, $5,000 is insurmountable. If they're unemployed, if they're disabled, if they don't have the ability to earn money. In other cases, $50,000 to $75,000 in credit card debt is enough to put somebody over the limit where they just cannot deal with it anymore. So it's kind of a personal situation that we look at, but it's usually if someone's calling and looking for help and they come in the office, more likely than not, they need the help. But we're not going to file a case if someone doesn't have a significant debt.
Well, let me ask you this. I mean, if somebody were disabled or they didn't have a job or they were getting Social Security, then the creditors really couldn't really touch them at that point, could they?
Well, the creditors can harass them. They can bring
so for
lawsuits.
your emotional stability and your well-being,
yeah, it's much like a corporation that goes out of business that doesn't necessarily need to file. You still want to do it to bring the finality so you don't face a lawsuit down the road.
Kevin from Batavia wants to know, will I be able to buy a house again if I walk away from my current mortgage?
Straight answer is yes. You will be able to buy a house again. It just depends on how long you can wait to qualify. It usually takes approximately 2 years to qualify for a decent mortgage after you've eliminated the debt in a bankruptcy, and probably the same time frame if you haven't eliminated the debt in a bankruptcy. You just have to make sure that you have the ability to afford that next home. Do you have a down payment? Do you have anything saved up? Are you working? Do you have the ability to make the payment? So yes, you can get a home after you file for bankruptcy, or even if you don't file for bankruptcy.
Awesome.
Thank you, Jesse. Good to join you today.
You as well.
You've been watching Legal Action. My name is David Siegel. We'll see you next time. You take care. Bye-bye.